Welcome to the third of 3 videos on venue. This video will focus on the common law doctrine of forum nonconvenes and forum selection clauses. Now, we've seen how the federal courts address transfers between districts within the United States, right? That's 281406, which cures mistakes, and 28 USC 1404 that will adjust venue for convenience in the interest of justice. But what happens when the better forum isn't just in another federal district, it's in another country? Congress never extended 28 USC 1404 beyond the US borders. So what is a practitioner to do? They rely on the common law doctrine of forum nonconvenes. Forum nonconvenes is a common law principle because it was developed by federal courts, not by statutes enacted by Congress. This common law principle escapes Erie Doctrine scrutiny because the United States Supreme Court justifies it not as a general common law, but rather as a housekeeping rule, right? It's considered a procedural doctrine, not a rule of substantive law. The principle of forum nonconvenes regulates where a case may be heard, not what law governs or what rights the parties have. It simply reflects the federal court's inherent authority to decline jurisdiction for reasons of convenience and justice. The leading case to show us how this common law principle works is Piper Aircraft v. Reno. So let's take a look at the Piper case. But before we do, just a little bit of background. This is a case about a small commercial aircraft. The aircraft is manufactured by Piper. That's in Pennsylvania. The propeller for the aircraft is manufactured by a company named Hartzell Propeller. That's in Ohio, okay? The plane crash occurs in Scotland. The 5 passengers plus pilot that are killed in the crash are all Scottish citizens, okay? American plane, American propeller, crash in Scotland. The people on board that are now deceased are all Scottish citizens. The British Department of Trade investigated the crash, found no evidence of mechanical failure, and suspected pilot error. I know it doesn't sound very interesting, but this is where the plot thickens. 2 slides for me to track the procedural, tactical, strategic maneuvering that happens in this case. And once we get through it, you will see why this case is the perfect case to show you the principle of forum nonconvenes. All right, let's get started. Case starts with a California attorney. California attorney is going to file the lawsuit on behalf of the 5 deceased Scottish citizens, right, in California. Okay, how is that going to happen? I'll tell you. The California lawyer goes to California probate court asked the court to appoint her secretary, Miss Rayno, as the administratrix of the estates of the 5 Scottish citizens now deceased. Yeah. The California probate court, hearing no objection, makes said appointment. So now the legal secretary has the legal standing to represent the estates of the 5 Scottish citizens who died in the crash. That's step one. So now we have an American citizen who has legal standing to bring the lawsuit in the United States. Okay. Once that's done, Rayno, the administratrix, files a wrongful death action in California state court for these 5 deceased Scottish citizens. That's how the litigation begins. Who's being sued? Piper, the manufacturer of the aircraft in Pennsylvania, is defendant one. Hartzell, the company that made the propeller on the plane out of Ohio, is defendant two. Okay, so California State Court, defendant one out of Pennsylvania, defendant two out of Ohio. Plaintiff is a citizen in California. Great, we're in state court. However, by doing this, you see what happens, right? It's line number 3 on the table. What happens is the California attorney just created the perfect scenario for diversity jurisdiction. Now, mind you, the plaintiff is the master of the complaint. The plaintiff did not file in federal court. She filed in state court. Nonetheless, the defendants remove the California state court claim to federal court, right? They move it to the Central District of California federal court. How did they do that? 28 USC 1441 and 1446. Why? Because there was diversity of jurisdiction, right? We've got complete diversity amongst the parties, and the amount in controversy exceeds $75,000 plus cost and interest, right? So you're thinking, great, okay, still not quite sure how this California lawyer and her secretary get involved. But if we can go beyond that and just look at the procedure, we understand. State court removed to federal court, removed to the Central District, because that would have been the geographical location, we assume, right? That is the closest to where the state court sat. Are we done? Not even close. We're just getting started. After the defendant removed the case to federal court, they then, in federal court, file the motion to transfer. Of course they did. Of course they did, right? They file a motion to transfer from the Central District in California, federal court, to the Middle District of Pennsylvania. Why Pennsylvania? Because that's where Piper is manufactured. Brilliant, right? How did they do that? They did that under 28 USC 1404. Federal venue transferred. Got it? Brilliant. Brilliant. This is almost like a review for a final exam. Are we done? We're not done. We're not done. Once it gets transferred to the federal court in Pennsylvania, the defendants then file a motion to dismiss the case entirely, arguing that Scotland is also a proper form, right? Scotland is also a proper form because what? That is where a substantial amount of events that make up the claim sit. Common law doctrine, form non convenes, right? Common law doctrine, form, form non convenes. Why are we not going to rely on 1404? Well, remember in the opening slides, I reminded us that Congress never intended 28 USC 1404 to be used outside of U.S. territory. So we can't use 28 USC 1404 to transfer from the federal court in Pennsylvania to a court in Scotland. So how do we get it out of the United States back to Scotland? Common law doctrine, form non convenes. Is this brilliant or what? Yeah, pretty freaking brilliant. But we're not done, because at this point, all the defendants are doing is asking the court to dismiss the case here, right, without prejudice, because there is a better place for this case to be heard, but it's outside of the United States. What did the district court, that's the Middle District of Pennsylvania federal court, what did they do? They granted the motion to dismiss, right? The court found that Scotland was clearly more convenient and better connected, right? The plane crashed in Scotland. The crash was investigated by an investigator that's closer to Scotland. There's witnesses, more than likely, in Scotland. My goodness, the people who died in the plane crash are citizens of Scotland. Of course. Let's get this case out of the Middle District of Pennsylvania, right? That doesn't have any vested interest in the resolution of this case. Even though venue's proper, let's get it to another place where venue's proper, right? And let's go on with justice. Great. Are we done? We are not. Look at line number 8. Of course, the California Attorney appeals, right? And the Third Circuit, the appeals court, reverses it, reverses the dismissal, holding that the dismissal was improper. Look at the findings. Look at the reason why the appeals court reversed it. The appeals court said that Scottish law provides a less favorable remedy for the plaintiffs. So why would we send a case to a country that is going to disadvantage the plaintiffs when we can hear the case here in the United States, which will advantage the plaintiffs? This is the epitome of forum shopping. Absolutely the epitome of forum shopping, right? The appellate court prioritized the plaintiff's loss of advantage as the reason to retain the case in the United States. Well, the United States Supreme Court grants certiorari, and so they review the case, and the United States Supreme Court reverses the third court's reversal of the dismissal. And this is what we have today. The United States Supreme Court held that a less favorable foreign law does not prevent dismissal. What matters is the adequacy of the alternative form and the balancing of convenience. If the Scotland form is able to adequately address the case, then let Scotland, where a majority of all the events that make the case, adjudicate the case. Done and done. That's the Piper case. See how form nonconvenes works, right? We couldn't use 1404 to get it from federal court in Pennsylvania to Scotland, but we can use the common law principle of doctrine of form nonconvenes. Now, you might be asking, why did we start in California to begin with? Well, California in the 70s and the 80s had the most expansive tort doctrines in the United States, right? And if a case was based on strict products liability, then California was known to award very generous judgments. Yeah. Um, and in addition, the California attorney knew California law. So there's an advantage. And hold on, we're not done. At the time, California had more of a liberal discovery policy, which means that you're going to be able to get more information from the other side as part as trial preparation, which is going to support a even larger, more generous damage award. And it was noted that California juries were perceived as sympathetic to plaintiffs, right? Especially in wrongful death cases. So by filing in California, was it possible that the attorney was being zealous and just trying to get the best damage award for their client? Yeah. Was that beyond the expectation of what we mean by zealous representation entering into the land of forum shopping? Absolutely, right? Because why? What's the motivation? The California attorney specifically chose California state court as the place to file the case, right? Even though California had absolutely nothing to do with this case. Nothing to do with this case. And so, yeah, we've got some forum shopping, but that's why California, okay? The United States Supreme Court in Piper notes the forum shopping aspect, right? Because as you probably could imagine, the United States Supreme Court wasn't really happy about what clearly was the motivation. And the United States Supreme Court said this, and I quote, Reno candidly admits that the action against Piper and Hartzell was filed in the United States because its laws regarding liability, capacity to sue, and damages are more favorable than those in Scotland. Again, absolutely the definition of forum shopping, which is exactly what we are not supposed to do. Okay. What's the rule of forum nonconvenes? If I'm writing an essay exam and I'm expected to provide a rule statement, a federal court may dismiss a case when an adequate alternative forum exists and when the balance of private and public interest factors strongly favors the foreign forum. So forum nonconvenes is essentially 28 USC's 1404's international twin, right? We dismiss, not transfer, but we dismiss the case here so that it can be filed in a more appropriate form. Note, this was not the wrong form. It was not the most convenient form. So because 28 USC 1404A and the common law principle of forum nonconvenience are relatively similar, I give you a chart of comparison, right? So the legal source, 28 USC 1404 comes from 28 USC 1404. Forum nonconvenes comes from where? There's not a statute, remember, it is a common law principle. Okay, all right. Well, when do I use 1404A? You use that when the case is filed properly, right, in a U.S. federal venue, but there's another U.S. district that's more convenient. That's 1404. When would you use forum nonconvenes? You'd use forum nonconvenes when the case is filed in a proper, right? It's still proper U.S. venue, but there is a better forum, but it's in a foreign country. What does 1404 allow? It allows for transfer. What does forum nonconvenes allow? It allows for dismissal, right? What's the result of a 1404 transfer? The case continues in federal court, just in a different district. What is the result of forum nonconvenes? The case ends in the U.S. court, right? It is dismissed. Get it? The purpose of 28 USC 1404A, optimize convenience and fairness. The purpose of forum nonconvenes is to respect comity, fairness, and practicality when the litigation belongs outside of the United States. What is the authority? Well, for 28 USC 1404 is 28 USC 1404. And forum nonconvenes because, again, it's federally court created, not enacted by Congress, right? It's not a statute. The common law principle of forum nonconvenes was birthed in the Gulf Oil versus Gilbert case in 1947. Yeah? Fantastic. Let's keep moving. Let's keep moving. What does that bring us to? It brings us to a simple review of venue. Doctrine 1406, that's when venue is wrong. That's our curative doctrine, remember, where the court shall dismiss or, in the interest of justice, may transfer. 28 USC 1404 is when venue is proper and it allows for a transfer. And then we have the common law principle of forum nonconvenes. Venue is proper, but there is a more appropriate venue that lies outside of the United States. That is the common law principle of forum nonconvenes. So that now takes us to the last focus for our venue doctrines, and that is forum selection clauses. Forum selection clauses. That's not forum shopping, forum selection clauses. Okay? Up to this point, we've discussed forum nonconvenes. That is a common law principle rooted in judicial discretion, right? It allows the court, even when jurisdiction and venue are proper, it allows the court to decline to hear a case if another forum would be substantially more convenient or fair. That's the court exercising its own authority to manage the forum in the interest of justice. What happens when the parties themselves have made a decision, right? Forum nonconvenes, that's a court decision. But what happens when the parties have made the decision, right? What if, long before any dispute arises, The parties agree contractually where any future lawsuit will be filed. Well, we're familiar with this. Remember the Burger King case? Yes, it's a personal jurisdiction case that's what we use to teach, right? One of the steps in the evolution of personal jurisdiction, right? And Burger King also birthed our 5 factors for traditional notions of substantial justice and fair play, right? But Burger King is also a great example of a forum selection clause, right? Great example of a forum selection clause. And so, with the forum selection clause, it takes the world of judicial discretion out of the picture, right? And yields to a world of contractual autonomy. Lovely. Let's talk just a little bit more about the concept of forum selection clauses. On this slide, that's slide 61, it shows the doctrinal handoff, right? The moment where judicial discretion yields to party autonomy. In the center column, what we have is forum non-convenes. That's the court's power to manage convenience. In the right column, what we have is forum selection clauses. That's the party's power to pre-select their forum. Notice in the forum non-convenes, the timing is after we have a dispute. If you look at the timing of the forum selection clauses, it's pre-dispute. Look at forum non-convenes. What's the core question? Is another forum substantially more convenient? But what is the core question when we're looking at forum selection clauses? Should the parties' agreement as to forum be enforced? Under forum non-convenes, the controlling principle is fairness and practicality. Under forum selection clauses, freedom of contract and predictability, right? Leading cases, presumptions, policy objectiveness. So you see that if you utilize a forum selection clause, that's allowing the parties to exercise their right to contract, right? And to exercise autonomy and to try to prevent potential disputes that may arise, right? Tries to prevent it before it actually happens. If a forum selection clause is deemed to be valid, then how does the court actually enforce it? Well, let's look at it. We've seen what a forum selection clause is. It's a pre-dispute agreement by the parties on where they will litigate. But how does the court actually enforce the forum selection clause once a case is filed in the quote unquote wrong form? Well, first, it's important to know that there is no statute that governs, I'm going to say it again, there is no statute that governs, right, forum selection clauses. Congress never passed a statute that says forum selection clauses are enforceable and this is the way we do it. Instead, the enforceability of forum selection clauses comes entirely from case law, and it starts with the Bremen v. Zapata offshore company case, right? That's where it starts. So here's the key. What you see in Bremen is the court utilizing 1404 to enforce the form selection clause, right? 1404 does not mandate, does not validate, does not direct form selection clauses, but it does serve as the mechanism by which the transfer, if one needs to be done, actually take place. Okay. Let's keep going with a quick review. The underlying rule that the party's chosen form should be respected still comes from judicial precedent, not statute, however, right? And that's why you hear form selection law is statutory in form, judicial in principle, but contractual in its origin. Get it? Form selection clauses. I've listed some cases. Again, I'm going to take you to the Bremen v. Zapata case as the prevailing case for form selection clauses, if you want to review that to see how the court applies it. Okay. Now that we've seen how 1404 and the common law of form nonconvenes work together to enforce these clauses, let's pull everything together, one framework. Pull everything together, one framework. And that's this slide. This slide pulls together everything we've discussed so far and shows how the three sources of authority, that's statutory authority, judicial authority, and contractual autonomy, interact to produce the modern law of form selection, right? First, notice 28 U.S.C. 1404 sits in the left column. This is Congress's contribution. It's the procedural tool that lets federal courts transfer cases between districts for the convenience of parties and witnesses in the interest of justice. When a form selection clause designates another federal district, 1404 is what the court uses to move the case. Second, let's look at the form nonconvenes row. This remains the common law mechanism for enforcing clauses that point outside the federal system. For example, to a state or foreign form, right? This, you already know from the Piper case. The doctrine survives because 1404 cannot transfer cases to non-federal courts, which would be what is required if we're dismissing it in a U.S. federal court so that it can be filed in a court outside of the United States. Third, federal common law row. This is the substantive rule of enforceability, right? The part that says form selection clauses are presumptively valid unless enforcement would be unreasonable or unjust. That's the rule that comes out of Bremen. Finally, the state contract law row. State law still matters, it does, not to decide whether the clause is enforceable, but to interpret what the clause means, right? What counts as arising out of the contract? Did the parties intend exclusivity or did they intend permissiveness, right? Those interpretive questions remain governed by ordinary contract principles. So here's the big picture. Form selection law is a hybrid. It is statutory in its mechanism, right? Statutory in its mechanism, judicial in its enforceability, contractual in its origin. Each branch plays its part, right? Congress provides the procedural tool, the courts supply the doctrinal rule, and the parties provide the consent that makes the system legitimate. Together, they create predictability in an otherwise chaotic world of multi-jurisdictional language. That's a lot. Now that we've mapped the sources of authority, the next step is to look at the limits, right? What are the limits on the parties' autonomy to select their forum? Because even though the parties can pre-select the forum, they cannot rewrite the Constitution or override Congress mandates, right? Override congressional mandates. On the next slide, we're going to examine those boundaries. Ready? Let's take a look. There we go. Lots of tables. We're going to end this segment where all good civil procedure discussions end. Where's that? The limit of power. Up to now, we've celebrated the freedoms that parties have to choose their forum in advance by utilizing the forum selection clause option. That autonomy promotes efficiency, predictability, and comity. But that autonomy is not absolute, right? It exists inside boundaries drawn by the Constitution, Congress, and public policy. So let's just walk through it. First, subject matter jurisdiction. No contract can create subject matter jurisdiction. Remember that, right? Subject matter jurisdiction is not waivable. The Constitution and Congress alone define the scope of federal judicial power. You cannot agree to litigate in federal court if your case does not satisfy 1331, which is federal question, 1332, diversity. You cannot litigate a state claim in federal court unless, right, what? You're following what? 1367, right? And that's because jurisdiction concerns, authority of the court concerns are not based upon convenience. Remember, federal courts are courts of limited jurisdiction. Remember the history that we went through when we talked about subject matter jurisdiction. Remember Article 3, Section 2, right? Congress is very protective of what types of cases will be allowed to come to the federal court. Second, personal jurisdiction. Okay, a forum selection clause may operate as consent to personal jurisdiction, but only if due process is still satisfied. You can't get rid of these constitutional protections, right? There must be a rational relationship between the forum that's selected, the parties, or the transaction. Do not forget Burger King v. Resowicz. Do not forget it. Burger King made clear that contractual consent is powerful, but not unlimited. It's powerful, but it's not unlimited. Consent cannot cure a form that is fundamentally unfair, right? Constitutional protections. Third, venue. Venue is statutory. We know that it's governed by 28 U.S.C. 1391. A forum selection clause cannot make venue proper where Congress has said it is not proper. Now, it can justify a transfer under 28 U.S.C. 1404A or a dismissal under the principle of forum nonconvenes, right? That's the balance. That's the balance. The clause doesn't change the venue statute. It just changes how the court applies it. And then there's always public policy concerns, always public policy concerns to consider. Even a facially valid clause may be disregarded if enforcing it would be unjust or contrary to strong public policy. I point you back to the Bremen case, right? I point you back to the Bremen case. These four limits, jurisdiction, due process, venue, and policy, form the outer wall of enforceability for form selection clauses, right? The clauses reflect the power of private ordering, but they operate within a system where judicial power, statutory command, and public fairness remain supreme. Freedom of contract ends where court power begins. Freedom of contract ends where court power begins. This final slide sums up everything we've covered in one quick framework. Ready? What a form selection clause can do and what it cannot do. Let's start with the left column. What these clauses can do. They can designate the form system. Texas state courts, United States District Court for the Southern District of Texas, etc. They can identify the precise geographic venue. They can operate as consent to personal jurisdiction if the form has a rational connection and due process is met. And they can express the parties' contractual preferences. Contractual preferences. Okay? What they cannot do, they cannot create subject matter jurisdiction. They cannot rewrite the venue statutes. They cannot override due process or fairness. And they cannot defeat strong public policy. So this slide, slide 65, can serve as your quick reference chart for form selection clauses, right? Quick reference guide. Thoughts, ideas, that silence was intended. This brings our venue series to a close. I hope that the videos have helped. I hope if you have any questions, you can refer back to the videos as you review or as you answer questions or as you polish up on your understanding of venue. I look forward to seeing you in the next series of videos.